In this video, I'm going to be talking to you about hearsay evidence, hearsay within the context of criminal law. Hearsay is a huge topic, so I'm just going to focus on one aspect of hearsay, and that is defining what hearsay evidence actually is. I'm going to be referring to case law and statute law throughout this video. So let's begin by defining what hearsay evidence actually is. Generally, hearsay evidence is a second-hand account of relevant information. Normally, when a witness gives evidence in court, they give evidence about events that they actually experienced, perceived, heard, or saw themselves. Hearsay evidence, on the other hand, is evidence given by someone who didn't actually witness or perceive, hear, or see the events themselves. They are given evidence about information that they obtained secondhand. The following illustration demonstrates the principle of hearsay.
Hello, Christopher.
Are you alright? What happened?
Christopher punched me in the face.
So in this scenario, we see that poor Mr. James has been punched in the face by Christopher. Mrs. Patel goes to Mr. James's aid, but she didn't actually witness the punch. She didn't actually witness Mr. James being assaulted. I want you now to imagine that Christopher has been charged with assault and that he's being tried in the Crown Court. The witnesses, Mrs. Patel and Mr. James, are in court to give evidence about the events.
How did you come to be injured?
Christopher punched me in the face.
How many times did he punch you?
Once.
Is Mr. James's evidence hearsay? No, of course not. He's simply given evidence of what he actually experienced himself. He's given a first-hand account of being punched in the face. So let's return to the scenario. Mrs. Patel is about to give evidence.
What did you observe?
I saw a man lying on the pavement. His hand was covering his right eye.
What did you do next?
I approached him and asked him what happened. He told me that someone called Christopher had punched him. His precise words were, "Christopher punched me."
So Mrs. Patel has given evidence of what she was told. Is that hearsay? Yeah, absolutely. It's hearsay evidence because she didn't personally witness Christopher punching Mr. James. She was told that Christopher had punched Mr. James, and therefore her evidence is hearsay evidence. So why do we need to identify hearsay evidence? We need to identify hearsay evidence because generally hearsay evidence is inadmissible unless certain exceptions apply. And why is it that hearsay evidence is generally inadmissible? Well, hearsay evidence is not the best evidence. It's a second-hand account and therefore it's second best. Often, hearsay evidence is seen as being less reliable. Witnesses are human beings after all, and human beings are not infallible. Human beings make mistakes. And so a witness may inaccurately remember what they were told, or may have been mistaken in what they thought they heard, or they may unconsciously exaggerate what they thought they heard or saw. The next scenario should illustrate this point.
My wife is beastly.
Hi John, how are you?
Guess what?
What?
Dennis told me something about his wife.
What did he say?
He said, "My wife beats me."
See what I mean? I should say at this point that where hearsay evidence is admitted into court, there are certain safeguards that are put in place to ensure that a person against whom the hearsay evidence is adduced is not prejudiced by its admission. So I now want to turn to statute. And the main provision dealing with hearsay evidence is the Criminal Justice Act 2003. And the default position is that hearsay evidence is inadmissible unless it qualifies for admission under one of four gateways. Interestingly, hearsay is not actually defined under the Act. It sets out the circumstances in which hearsay evidence may be admissible in court. So let's look at the relevant statutory provision. So Section 114 of the Criminal Justice Act 2003 is the provision that deals with the admissibility of hearsay. And I suggest at this point that you pause the video and just read through Section 114 and then resume the video when you have finished reading the slide. So there are two important concepts that I think we need to explore. And the first concept is statement. So what is meant by statement? And the second concept is matter stated. So let's have a look at both of those concepts in turn. So the first concept, statement, is defined in Section 115, Subsection 2 of the Criminal Justice Act 2003. And again, I suggest at this stage you simply pause the video and read Section 115, Subsection 2 to yourself. Now, Section 115, Subsection 2 is quite a straightforward provision. But there are two matters that I would like to draw to your attention in relation to this provision. And the first matter is this: a representation can be made by conduct such as a gesture. So if somebody did that, clearly that's a gesture, it's a statement. Secondly, the second matter that I'd like to draw your attention to is a statement of a person's current intention is also a representation. All right, let's move on then. So the second concept that I want to look at is matter stated. So what do we mean by matter stated? Now again, that is dealt with in Section 115 of the Criminal Justice Act, Subsection 3. So again, I'd like you to pause the video and read that provision to yourself. Resume the video when you have read the slide. Now, Section 115, Subsection 3 is concerned with the intent of the maker of the statement. So if the maker of the original statement intended the recipient, the receiver, to believe the statement as being true, it would be hearsay if the recipient of the statement were to give that evidence in court. And clearly the evidence would be inadmissible unless it fell within one of the four gateways set out in Section 114 of the Criminal Justice Act. Let's move on. It's not always easy to determine whether or not a statement is in fact hearsay. And in Art and Twist, the Court of Appeal set out 3 questions that should be asked and answered in order to determine whether a communication or a statement is in fact hearsay. And so the questions are on the screen. And again, I would suggest that you simply pause the recording, read the questions to yourself, and then resume the recording when you're ready. So now I'm going to use the facts of a reported Court of Appeal decision in order to demonstrate the twist principles. I'm going to put the facts of the decision on the next 2 slides. And again, I suggest that you read the facts, pause the recording to enable you to read the next 2 slides. Okay, so remember, the relevant text message, the relevant communication is the one that said this is the one face melter with the picture next to it, the picture of the box containing the acid. So that's the relevant communication. And the principal issue for determination was whether the message had been hearsay evidence. We're going to go through the 3 twist questions in order to determine whether or not that communication was in fact hearsay. So the first question to be asked. Oh, I'm in the way. Let's see if I can move out of the way so you can read. Yeah, that's better, isn't it? Okay, so the first question that needs to be asked and answered is, what relevant matter, the statement is intended to prove? Now, if you were prosecuting, what would be the relevance of adducing the communication? What is the relevance of this is the one face melter? Well, the prosecution had sought to use the message to show that the product had not been purchased with the intention of using it as a toilet cleaner or drain cleaner. It had been purchased with the intention of using it as a substance to be thrown in the complainant's face in order to cause really serious harm. So that's the first question. The second twist question is to ask whether there is a statement of that matter in the communication. Well, the text amounted to an implied representation of intention, and that representation was shared by the defendant as well as his half-brother. And the implied representation of intention was to cause really serious harm to the complainant. So we need to turn now to the third question. We have to ask whether it was one of the purposes of the maker of the communication that the recipient or any other person should believe that matter or act upon it as true. So we need to ask ourselves, was it the purpose of the half-brother when he sent the message to his girlfriend that she actually believed that the acid was in fact or could in fact melt a face? The Court of Appeal held that nothing in the message could possibly suggest that it had been sent by the half-brother to cause the girlfriend to believe that one shot would actually melt a face. Therefore, the message was not hearsay and had been admissible. Now, the name of that case is R and Midmore, and I would invite you to read that case if you haven't already done so. It's very, very interesting, and it sets out the hearsay principles very, very clearly. So hopefully you should now have a better understanding of what hearsay actually is. In another video, I'm going to talk about the exceptions to hearsay. In other words, I'm going to look at the circumstances in which hearsay evidence will be admissible in court. Thank you for watching this video. Please like this video, please share this video, and please subscribe to my YouTube channel, Advocacy Tutor.